So now we are going to move into the first of our substantive panels. We have two just absolutely excellent experts in the field, and among their very myriad IP practice areas, they each practice in a range of IP, but they're both experts in the area of the right of publicity. And as many of you know, there's been a lot going on in that area this year. And the thrust of this panel, of course, is going to focus on the big developments in California, the Fair Pay to Play Act. And obviously, those of us concerned with IP social justice are watching that legislation very closely. So our two panelists, and I won't go through their extensive bios because they are on the course materials USB that you received. Our first presentation is going to be Mr. Ronald Katz. Our second presenter is going to be Jonathan Goins. And again, take a look at their bios, which if I went through it, we would be well into the afternoon. So instead, I'm going to let them do what they do best, and that is to speak and to educate. And so let's start first with Ron Katz.
Thank you, Professor Matima. Most of you probably don't know that Professor Matima and I used to try cases together. And actually, to tell the truth, I was quite disappointed when he decided to become a professor, because I think he was a great trial lawyer. But he saw something that I didn't see and that not many people saw, and that is that intellectual property law can function as a civil rights law as well. And that's what brings us all here today, is issues of social justice. And quite frankly, I have an easy one to discuss, and that's the social justice, or the lack thereof, with the National Collegiate Athletic Association. So let me make that point by just starting by asking a question, and that is, how many people in this room think that it's fair that the NCAA can have a multi-billion-dollar organization with multi-million-dollar facilities, with coaches making $10 million a year, with assistant coaches making $1 million a year, with weight trainers making $500,000 a year, and the athletes who generate all this entertainment and income receive nothing but the cost of attendance at college? How many people here think that that is fair? Nobody. Of course not. It's very unfair, and that's why we're here, social justice. And the reason that it's unfair, the reason that this has developed, is that the NCAA is an unprincipled organization. Now, I don't mean that in a pejorative sense. I'm not here to call names to anybody. But they truly are an unprincipled organization, because supposedly they are based on the principle of amateurism. But they cannot define what amateurism is. And everything that I've just told you is contrary to what amateurism comes from. The Latin word to love. It means you're doing something just for the love of it. You're not making money. You're just doing it for fun or because you like it. That is not the case with college athletics these days. And the proof that the NCAA was unable to define amateurism came recently in a case in California, a case which is called INRAE, the National Collegiate Athletic Association, Grant and Aid Cap Antitrust Litigation. That's a mouthful. But you would think that this case, in fact, yesterday, the plaintiff's attorneys just were awarded $33 million in fees by the court. So you can see it was a pretty big case. You would think that the NCAA would come prepared. If they were prepared for anything, they would be prepared to define the word amateurism. That is the essence of what the NCAA is. And in fact, I have some quotes here from some of the people from the NCAA who were asked about amateurism. The former commissioner of the SEC, the most important football conference, testified, You know, the term amateur, I've never been clear on what is meant by either in your question or otherwise. What is really meant by amateurism? That was his answer. A representative from the Pac-12, the big conference out where I am in California, testified as follows. Amateurism is a series of things you cannot do, and by then still remain an amateur. It doesn't exactly have a beautiful definition. And the court criticized this. The court said that the NCAA in the trial, this was in her 110-page decision, the NCAA offered no standalone definition of amateurism either in the NCAA rules or in argument. The principle of amateurism, as described in the current version of the NCAA's Constitution, uses the word amateurs to describe the amateurism principle and is thus circular. It does not mention compensation or payment. And the court concluded that the NCAA rules that permit, limit, or forbid student-athlete compensation and benefits do not follow any coherent definition of amateurism. So that's why none of you think that this is fair, because there's no principle undergirding it. And in fact, the judge found that athletes were compensated in about 17 different ways. If you make the Olympics, if you make a bowl game, there's special student funds. There's no rhyme or reason to it. It's not bad to compensate athletes, but there's no rhyme or reason to it. So that's the problem. The problem is that you cannot really distinguish. At the upper levels, you cannot really distinguish the NCAA from professional athletics. There's only one distinction. They don't pay their athletes. Who ever heard of such a thing? Well, we have heard of such a thing, unfortunately, where you have an enterprise and you don't pay people. But who ever heard of it in this day and age? So what we're going to talk about today is names, images, and likenesses. Compensation for names, images, and likenesses. But this is just a symptom of the problem. The underlying problem is the NCAA is unprincipled. That amateurism doesn't exist in the end. If you want amateurism, go out and play with your dog. That's amateurism. Play with your kids. But it doesn't exist in this multi-billion-dollar enterprise. But let's talk a little bit about names, images, and likenesses. And what is the history of this? Well, on the board here, you see what the student athletes have to sign. They have to release any and all rights for use of their name, image, or likeness in any form forever and throughout the universe. Well, I don't know who drafted this. They probably weren't thinking that I'd be talking about it at lunch today. But, I mean, that is bad. That power corrupts, and absolute power corrupts absolutely. That is bad. Nobody could say that that's good. But it's worse. What's worse is that who's signing this? Who's signing this on the other side? A 17-year-old kid is signing this. They're not even of an age when they can legally sign a contract. And when are they signing this? They're signing it right before their first practice. So here, they've worked their whole lives. They're great athletes. They've come through college, through high school. They're stars. They've performed under pressure. They've gotten a scholarship to a great university. They're about to go to their first practice. I mean, they're hyped up. They're kids. They're 17 years old. And they say, well, there's just one thing. You have to sign this first. And furthermore, if you don't sign it, you can't go out on that practice field. Well, how long do you think it takes that kid to sign this document? Like 1 nanosecond. But it's even worse than that. Because the whole idea of this, the whole idea of the paternalistic NCAA is, well, we have to protect these children. We have to protect these kids because people can't exploit their names. There's only one organization that can exploit their names, and it has 4 initials, the NCAA. If you're Shaquille O'Neal or if you're Chris Webber, you can go down to the student store and you can buy a jersey with your name on the back of it. You can buy it. You don't get any money for it. The NCAA gets the money. The university gets the money. So it's basically, you can't do it. I need to use it? Okay. Oh, I see. Okay. You can't. I do that. You can't do that, but we can do it. It's bad if you do it, but it's not bad if we do it. So you can imagine how I've been working on right of publicity for athletes for about 25 years. And at first, we're just a voice in the wilderness because basically college athletes did not have much power. I represented retired professional athletes. They did not have much power. The only power that they could have came from the legal system in terms of a class action. Then you can get people's attention. And that is exactly what's happened. And virtually all of those class actions have been won. But it's a huge battle because the NCAA never gives an inch. They lose every litigation, but they never give an inch before the litigation. So you can imagine how delighted I was when I heard that my state, the state of California, the great state of California, was going to legislate to provide for the payment of student athletes, and I don't even call them student athletes. They're students. They're not student athletes. They're students. They're just like everybody else. And that's another thing that's unfair. If you're a student and not an athlete, you can promote your name, image, and likeness as much as you want. But if you are an athlete, you're a second-class citizen. You may not do that. So California decided to do something about that. And last September, they passed this legislation, which I'm sure you have all read about, which said that I'll say student athletes or athletes, can be paid for their images. Now, this is no skin off the NCAA's nose, because it's not as if the NCAA is paying them. It's not as if their university is paying them. It's like Chevrolet is paying them, or AT&T is paying them. What do they care? Why? The NCAA not only wants to regulate what the student athletes do, but they want to regulate what AT&T does, what Chevrolet does. And so they said, go ahead. They said, basically, no one can stop a student. It's illegal in California for anyone to try to stop a student athlete from making money on his name, image, or likeness. And this set off a firestorm. The NCAA basically said, this will be the end of Western civilization as we know it. And it's true. I think it could end college athletics will end fairly soon, I think, because the NCAA has already lost control of football, and it won't be too long before somebody realizes they could do a better job on basketball than the NCAA does too. But in any event, they're right. It would be the end of the NCAA as we know it, because once you say that any payment is okay, then the sky is the limit. So let's say that the rule is you can't be paid to play. The university can't pay you $100,000 a year to play. So let's say that you're a great high school football player. You're the #1 recruit in the country. You're Andrew Luck. And Andrew Luck, people are competing. Universities are competing to get Andrew Luck to come. Well, they can't compete by paying him a salary, but they don't have to. They can just go to their local law firm or accounting firm or auto dealership or beer distributorship and say, look, you're a graduate of Stanford. You love Stanford. You want us to have a good team. We're having a hard time because we have all these 4.0 students here. They can't play football. But here's a guy who's a 4.0 student, and he can't play football. So let's get him. Say, okay, well, let's pay him $100,000 a year. Well, no, we can't pay him. We can just pay for his name, image, and likeness. Okay, well, let's pay him $100,000 a year for that. But he doesn't care. Andrew Luck doesn't care what you call it. He doesn't care if you call it a salary. He doesn't care if it's an under-the-table payment. He doesn't care if it's name, image, and likeness. It's money. And wherever he goes, he can spend that money. So that's why some people say this is the end of Western civilization as we know it. But then there's other people who say, and they're also right, this is sort of a self-contradictory kind of law professor type thing, that actually this law is meaningless. It is unconstitutional. And you know something? They're right. It is. And California legislators must have realized that. Because what they realized is that the best weapon against the NCAA is pressure. Headlines. People like in this room, nobody thinks the NCAA is fair. You know, that's not, you can't go on like that forever. So why is it unconstitutional? Well, we've had this case before. And California knew that this was coming because what they said was something very unusual. They said this law will come into effect in the year 2023, 4 years from the time that it was enacted. And the reason they said that is they just wanted to use it for pressure because they know it's unconstitutional. Now, why is it unconstitutional? How do we know it's unconstitutional? Because it regulates interstate commerce. Because we already had this case. There was a famous coach at the University of Nevada, Las Vegas, called Jerry Tarkanian. Tark the Shark. He was very successful. He had teams mainly composed of inner-city kids, and they were very, very successful. And as a result of that, the NCAA hated him. So if you wanted to give a course here, Professor Matima, in just the litigations of Jerry Tarkanian, it would take a year. I mean, he litigated. There's several cases that went to the Supreme Court. But there was one case in particular, because as you might imagine, Jerry Tarkanian was very popular in the state of Nevada. They really didn't care about the NCAA. If you had a vote, how many people like Jerry Tarkanian and how many people like the NCAA wouldn't come out very well for the NCAA. So what they did was they made a law. And they said, if any national sports organization wants to punish somebody in Las Vegas, not mentioning any names, just any national organization at all, if they want to punish somebody in Las Vegas, they have to follow due process of law. Now you'd say, well, you know, that doesn't sound very radical. Well, if you've ever been in an NCAA proceeding, you would know it's very radical because they do not follow due process of law. And in fact, the people who are judging you are your competitors. So if you're Jerry Tarkanian, you might be on a panel, you might be judged by a panel that had somebody from Kentucky on it, had somebody from Duke on it, who had a definite interest in shutting you down. And the NCAA sued, and what the court said, what the Ninth Circuit said, was, look, this is the National Collegiate Athletic Association. It's national organization. We cannot have differing regulations in different states. States cannot regulate interstate commerce. We can't have a state saying, for example, you know, you have to have a tire inflation different in Illinois from what you do in New York, because then you couldn't really have a national market. And it was obvious that it did regulate interstate commerce, and the Ninth Circuit ruled that that law was invalid. So on the one hand, you have the end of Western civilization as we know it, and on the other hand, you have an unconstitutional law that we won't find out about until 2023. And in the meantime, the NCAA has started its own committee, because they only react to pressure. They have started a committee on names, images, and likenesses, and they have said that you can, that they will devise a system for compensating players for their name, image, and likeness consistent with the college model. So I'm going to end by proving that everyone in this room is competent to be the president of the NCAA. Don't worry, it's going to be easy. How many people in this room know how to compensate an athlete for his name, image, and likeness in a way that is consistent with the college model? Nobody. And the president of the NCAA doesn't know that either. So you're equal with him. Thank you.
Thank you, Ryan. I'll try to get used to this mic without a mic. So my name is Jonathan Goins. I'm an intellectual property litigator. I'm at a firm called Brisbois in the Atlanta office. I've been doing IP now for 16 or 17 years. Stopped counting after a while. It's a pleasure to be here again. I'm a 2002 graduate of Howard, and I actually had Professor Mtima for torts and sales and secured transactions. But I did not have them for right of publicity or intellectual property. Those courses were still being developed by the time I graduated, and glad to see that those courses are taught now, thanks to you, Professor Jamar, and others who have been diligently trying to increase the intellectual property acumen for our next generation, specifically as it relates to social justice. And Ron mentioned that, hey, this is a social justice issue. For those who are in more of the traditional vein, like my dad, who's now a retired United Methodist minister after 40 years of service, civil rights to him is obviously in more of a traditional mode. And so when I was here at the law school, coming from that DNA background, I thought, okay, I want to be the next Thurgood Marshall. Maybe I'll try to be a judge or work for the NAACP Defense Fund. I had that type of traditional view of civil rights. But lo and behold, here I am 16 years later doing intellectual property still. And I was struggling trying to figure out, what does intellectual property and all these litigation matters have to do with civil rights, which is what I really wanted to at least do, at least in the beginning. And what I've developed over time and what I've learned is it has everything to do with civil rights. They go hand in hand. I have clients who are under work for hire assignments, and they want to get out of those assignments. So you talk about economic empowerment, ownership of your creative artwork, and I'm on both sides of those issues. And so I would encourage those of you who are students in the audience who want to do sports law or entertainment law. If you notice, neither Ron nor myself have self-identified as entertainment or sports lawyers, but more so intellectual property and right of publicity experts or lawyers, if you will. Those issues undercut every single industry that you can think of, whether it's technology, real estate, or what have you. So for the students in the audience, I just encourage you, just get a job, and lo and behold, trust in your higher power. You'll end up being able to do what you want to do, and it'll come together in a nucleus over time, as it has for me. So with that, Ron definitely talked about the basics of the California Fair Pay to Play Act. And what I want to talk about, because I am a litigator, are some of the exceptions to the same act that trouble me a little bit. And Ron's correct. The fact that this could be considered unconstitutional, he's not wrong in that context. But if I'm the attorney for the state of California, my argument is, well, this was limited to just students who want to participate and enroll within the state of California, inclusive of a private university. But obviously that's going to have a significant impact on the rest of the other states, because then you're going to have prospective student athletes or students who may certainly take away from revenue stream and athletic ability in other states. So what are other states doing to counteract that? To Ron's point, they're also attempting to adopt similar legislation. Just last week, Oklahoma, the state of Oklahoma, they passed a House bill similar to this act. You have Nevada, New York, Ohio, North Carolina, and Colorado that are also in the process of passing similar bills. Some of them are actually attempting to have their bills get passed and enacted prior to 2023. So the pressure is going to certainly continue to be on the NCAA and our dear friend Donald Remy, who's a Howard Law alumnus, 1991 graduate. So be aware, we have friends on both sides of the aisle maybe they have different perspectives than we do. No one raised their hand and said they opposed the California Act, but we do have alumni who mean well that may have a different take based on their constituency base. So the good news is this is definitely asserting pressure to have other states enact similar results. But sticking just to the California Act, I was troubled by the last two sentences of the bill that's enacted. It says the bill would prohibit a student athlete from entering into a contract providing compensation to the athlete for the use of the athlete's name, image, or likeness if a provision of the contract is in conflict with a provision of the athlete's team contract. So you can't prohibit a student athlete from receiving compensation for an endorsement deal off the field or off the court, so long as it does not, I'm quoting the bill, I'm not making this up, so long as it is not in conflict with a provision of the athlete's team contract. So if I'm a student athlete in my alma mater, University of Louisville, home of the Kentucky Derby, Muhammad Ali, and Bourbon, then I'm not going to be able to sign an endorsement deal with Nike, I don't think, because University of Louisville is under contract with Adidas. And there's a reason why all of the student athletes that are playing basketball for the University of Louisville wear Adidas uniforms. 45 miles to the east of Louisville, where my dad still lives, in Lexington, Kentucky, is the University of Kentucky, University of Kentucky Wildcats. They are a Nike school, as some would say. John Calipari and the University of Kentucky are under contract with Nike. So their student athletes are wearing Nike gear. So does that mean that if you're a student athlete and you have the opportunity to sign with Puma, that you can do so based upon the plain express language of this contract, of this bill? I think a lot of lawyers would say no. Can't be in conflict with a provision of the athlete's team contract. The bill would also prohibit a team contract. Oh, I'm sorry, So the bill would prohibit a team contract from preventing the student athlete from using the athlete's name, image, or likeness for a commercial purpose when the athlete is not engaged in official team activities as specified. The bill would prohibit a team contract from preventing the student athlete from using the athlete's name, image, or likeness for a commercial purpose when the athlete is not engaged in official team activities. So maybe that's a carve-out exception to the exception. So then I could possibly, if I'm a student at University of Louisville and the team contract is with Adidas, I could go and sign a contract with Nike so long as it's not as a part of quote-unquote official team activities. So the way that you would try to, attempting to try to actually practice this bill would be complicated just as much as it could implicate constitutional law issues. But another thing I would point out about this act, in addition to a student athlete being able to receive endorsement deals outside of team activities, not in conflict with the university or team's contract, they also have the right to obtain professional representation. So that means if you're going to be enrolled in California as of 2023, you get to hire CAA to help you negotiate your representation in connection with your student athletic activities. How does that play out? That could certainly implicate a lot of additional legal conflict. So I definitely think, without question, this is the first of many efforts to try to advance more fairness to student athletes and their ability to be able to receive compensation for their hard work and sweat. And it's just interesting to me that it's taken the legislator's side to do this, because certainly there have been a number of plaintiffs that have tried to do this from a litigation standpoint in the judiciary. And we can go back into the last several decades from Ken Waldrop, who became paralyzed after a tackle, landed head first, became basically a quadriplegic, sued the Texas Workers' Comp Committee and said, hey, I want workers' compensation. And went to Texas Supreme Court and Court of Appeals, and they said no, because you were a student athlete, not an employee, and only employees have the opportunity to receive workers' comp. And then we fast forward to 2014, we saw Northwestern University try to do the same thing. Their student athletes sued, or actually filed a petition with the National Labor Relations Board, and having them be deemed employees so that they could unionize and receive adequate representation. 2014, and they won, actually, but then it went to appeal before the regional NLB, and they reversed, saying that there was an issue over how this could impact or apply to public universities, given that Northwestern was a private university. And then, of course, also in 2014, we saw Judge Wilkin and her decision in California in favor of Ed O'Bannon, only to see that partially reversed. But Ed O'Bannon, Ken Waldrop, student athletes at Northwestern ought to be commended, because I think they have continued to, fight the good fight and add to where we are today. And Ed O'Bannon in particular, and his entire set of class of plaintiffs, they actually weren't even seeking compensation while they were playing. They said, upon our eligibility being expired, we simply want to be able to have a cut or share of the revenue from the licensing of video games, from endorsement deals, from commercial advertising, and from television broadcasts. And I think Judge Wilkins got it right, but Ninth Circuit Court of Appeals thought otherwise. And so, that's kind of where we are today. And I will just add one more thing. So I know we all have a particular view about this topic. And for me, I wasn't athletic enough to play basketball in Louisville. But but no question, I'm certainly on the side of student athletes. But there are contrary views, and we do need to engage with those views and continue to educate others to get them on our side. My brother-in-law, for instance, he's a former middle linebacker for University of Tennessee Vols. He played from 2002 to 2005. And he was asked to sign and be a part of the litigation involving Ed O'Bannon. And respectfully, to his credit, although I disagree, he chose not to. And the reason he chose not to was because he said, look, this is going to have a short-term impact on those other players, student athletes, who may not otherwise be well-known or highly regarded. Because guess what EA Sports did during the litigation involving Ed O'Bannon? They chose to stop and discontinue their EA Sports video games. So you could no longer actually play NCAA game that featured my brother-in-law on behalf of University of Tennessee. That started as a result of the waves of litigation. That was unintended short-term, I think, impact, because he said, hey, my name, image, and likeness is now no longer in a video game, even though I knew what the impact of what they were trying to accomplish. So it was a short-term defeat, but for a longer-term achievement, I think, because I'm now telling them, hey, now possibly Georgia, too, is going to have this name, image, and likeness wave of legislation. So there's going to be views on both sides of the aisle, and I've been on both sides of NCAA. I've worked for the NCAA through CLC, their collegiate licensing company, and enforcing their intellectual property for over 200 colleges and universities. And I've been on the opposite, where they sent a demand letter to a very well-regarded and popular high school, and that high school was using a logo that was similar to another college university. So there are always going to be both sides of the aisle, and I'm not trying to sound too much like a lawyer here, but we have to make sure we are seeing both sides so that we can further increase the chances that a judiciary, because this will end up still being back before a judiciary. Right now, it's kind of a short-term victory from the legislative side, but we can be rest assured, more likely than not, the NCAA will probably file a lawsuit or an injunction to prohibit this bill from being enacted in 2023. So we'll still end up having to deal with judiciary aspects. That's all I got.
So even though we're running a couple minutes behind, I'm going to add a few minutes to when we get to 2 o'clock. So we won't be taking minutes away from the upcoming presentation. But why don't we take just a couple minutes, no more than 5, to see if anybody in the audience has any questions or comments that they would like to share. Anybody have any questions? Anybody have any comments? Oh, yes, in the back, yes. So the question, I'm just going to paraphrase it for the taping, is whether or not purchasing, or perhaps you mean acquiring, the rights to utilize students' IP rights in terms of their likenesses and images, is that a mechanism to circumvent hiring them as employees? Did I get that right? Okay. Yeah.
Well, this whole concept of a student athlete is just a phony concept. It was conceived by a commissioner, a president of the NCAA, who specifically said he wanted to avoid the workers' comp laws. That's why it was done. And we now have, they say one and done. It's not really one and done. It's one half and done. I mean, I don't think Zion Williamson probably worked very hard after the NCAA tournament. I mean, with all due respect to him, he didn't have to. It wasn't, his future didn't matter to that. So whether this gets around that or not, the NCAA, this is like a core principle for the NCAA. We do not want to pay people who are injured. And a lot of these injuries go on beyond college. So as you know, a lot of these college athletes are just treated like meat. They're just treated like meat. Once they lose their usefulness, the school doesn't help them. And I know many, many athletes who have chronic injuries from their athletic, and not even the famous ones, you know, people who are swimmers. So, you know, swimmers have to swim so many laps per week. The shoulders are, you know, very, very vulnerable. So that's going to be their core principle. I would say they will certainly take the position that this gets around, you know, that they're just being paid for name, image, and likeness. They're not being paid by the university. They're not being paid by the NCAA. But at some point, they have to accede to this pressure, because the stories, like the Waldrop story, they're just too heart-wrenching. And what we take from these young people is too much, and then we just leave them, we just kick them to the curb.
Yeah, in the workers' comp context, that's really more so about whether or not student athlete could be classified as employees so that they could receive their benefits. The Waldrop case, you know, that had nothing to do with his name, image, or likeness. But your point is still valid in terms of mechanisms that are done contractually to be able to inhibit student athletes' rights per se, whether it's name, image, and likeness, workers' comp, or what have you. And more specifically, with respect to the release that most student athletes sign, you know, that doesn't have anything to do with whether or not they're deemed employees. The NCAA is saying, look, we get to use your name, image, and likeness in whatever context, whether it's during a game, whether it's through ticket sales and your face is on the ticket, whether through contracts that they may have with EA Sports and avatars that get portrayed featuring the same athlete's name, hometown, jersey number, height, signature, trademark, move, what have you. And so what you'll see to also, I think what you're trying to say or what you're asking basically, if I can answer your question as well, is you're going to have the NCAA, let's say this is held up in litigation and 2023 comes, California law is still enacted. You're probably going to see in-house lawyers at NCAA like Donald Remy revising this release language to conform only to or within the state of California or other states that have been enacted. But I don't think it's going to come to that at all.
Okay, we've got a final thought. Idris?
Is there any anticipated impact or let me rephrase. Should this be executed? So let's say that a student athlete decides to start a YouTube channel or advertise themselves as a personal trainer. You know, I'm an Alabama linebacker. I'm a star athlete, so on and so forth, and try to exploit their own likeness, but in the context of their role as a student athlete or athlete on behalf of a university. Might there be any limits in terms of how they're able to actually exploit themselves in an advertising context where part of their credentialing is based on the fact that they have a role within the university as an athlete on behalf of the university, but the counter argument is, well, I'm just, you know, essentially reciting my resume in an advertisement, and I happen to actually have this credential, so it's part of my resume. But do you expect universities to sort of have a backlash and say that this is a tacit endorsement and, you know, these are where our rights essentially take over and yours end? So you can talk about yourself and use your own likeness, but maybe there is no association available for you to be able to say that you're a student athlete here at the University of Alabama, Virginia, et cetera.
We already have the YouTube case, and that athlete is no longer on YouTube. So the rules are just completely screwed up. If you don't have principles, you can't make rules that make sense. The NCAA rule book is this thick. There are a couple cases on this. One involved a football player at Colorado named Jeremy Bloom. He was also a skier, and he was a professional skier. You're allowed under the rules to be a professional in another sport, but you may not promote that sport. So most skiers, for any of you here who are skiers, if that's what you call it on the East Coast, I don't know. All professional skiers have promotional contracts with the skis or the poles or whatever. He wasn't allowed to do that. And then recently, there was a female Notre Dame basketball player from a couple years ago who made the last-minute shots, and I can't pronounce her name. I'm sorry. Anugo, I can't pronounce her name. She was on Dancing with the Stars. And they said, okay, well, you can be on Dancing with the Stars because that's a different sport. Believe it or not, dancing is considered a sport. There's an international dancing organization. You can do that, but you cannot promote it. You can't appear on an advertisement for Dancing with the Stars. But, of course, Dancing with the Stars itself said, oh, well, she's coming, you know, watch next week because she's – so the whole distinction just made no sense whatsoever. But we're just in Never Never Land. And, you know, we need – well, there is no principle. Amateurism is dead. So, as I say, the NCAA will not – in 10 years, the NCAA will not exist.
It's just not clear to me that even if this is to sustain constitutional scrutiny, that the students will really be able to exploit their own likeness for whatever purpose they want.
Well, trust me, this is unconstitutional. And it will never – that's why they said 2023. They were smart, you know, because it's better if it's unconstitutional in 4 years than if it's unconstitutional right now.
Well, as engaging and intense as this discussion is, we've got even more engaging and more intense material coming right up. And so first, I'd like to thank our panelists for this panel presentation. And now I would like us to immediately segue into the second luncheon presentation. That one is entitled Remembering Invention of a Slave, Patents, and the Continuing Struggle for Civil Rights. We have two presenters, as is indicated on your agenda, Professor Kara W. Swanson, who is a professor of law and professor of history at the Northern University School of Law. And then right after that, we will have Brittany Amati, who is a partner at Wilmer Hale. And so first, Professor Swanson.